Okay, let's get to Jan Tinetti.
My afternoon since I have found out about this particular bill going through the different clauses of this bill. And so before I ask my first question of the Minister, I just want to outline how I intend my prosecution at this stage, the Committee of the Whole, to proceed, and then I will ask the Minister my first question. So what I've done, Mr Chair, is I've gone through the bill itself and gone through the different clauses and highlighted what I see are the most important parts to the different clauses, and then got some questions for the Minister in the different clauses. Now, along the way, I know that I have some amendment papers that I want to talk to, but I know a lot of my colleagues here have amendment papers that they will want to talk to as well. So that's what we have done. The reason that I've done it that particular way is because we haven't had the select committee process. And I have to say, Mr Chair, that since this was announced, I haven't seen my email blow up like I've seen it in the last few hours. And that's from people who are incredibly disgruntled around the process that has happened here. So some of the questions that I am going to ask are on behalf of people who would have normally come in to submit to that select committee process. So first off, Mr Speaker, I want to look at clause 4, and my colleague Camilla Bellich did talk a bit about clause 4, because that is the clause that does talk about the relevant work that is performed by the workforce that is at least 70% female, so it's increased that threshold. But it also talks about the work that has been performed by a workforce of that kind for at least 10 consecutive years before a claim is raised. I have some real concerns around this, and so I feel like, Mr Chair, that this is fundamental to the attack that was talked about in the first and second readings of this speech around that of women's rights and workers' rights. And as my colleague said, do women that are in workforces that have 60%, does that not count as a female-dominated workforce anymore, when obviously it is? So my first question puts both of those areas together, the percentage of women in the workforce and also the consecutive years. And that question is around what happens to a workforce that is performed by 65% of women for 9 years that has pay equity concerns in it. Now, this is the ridiculous situation we have here. Obviously, all of us in this House would say there are concerns around that need to be addressed. 65% female-dominated workforce has been an issue for 9 years with pay equity concerns. Do they not deserve a path to pay equity? Surely the answer isn't to say, well, no, because they're 5% short of that 70% threshold, or no, they have to wait a year. To me, that seems ridiculous, Minister. And is that what you were aiming for, to make it so hard and so difficult to raise a claim that those workforces, and they will exist, that those workforces would not have a pathway to a pay equity process? And it's a very serious question that came through from a number of people today to me, very, very concerned about the changes that have been made. They see themselves in a female-dominated workforce, but suddenly they're looking at this legislation and not seeing a place for themselves and seeing themselves marginalised even further. If that's what you meant, Minister, then that is a massive concern for this country and an absolute change to Labour law of the likes we haven't seen for many, many years.
The Honourable Minister.
I thank the member for her contribution. There's been a number of points made within her contribution about time periods and the threshold moving from 60 to 70% for female-dominated occupation. One thing I want to make clear is part of the reason why we have made these changes is we are moving away from having arguable claims to claims that have merit, which means that there must be an evidential basis for sex-based discrimination. And I think it's really important, because to make a claim, which is a very serious claim, that you're being discriminated on the grounds of your sex, is quite serious. And so there needs to be a justification for this claim. What we're saying is there needs to be evidence that you work in a predominantly female workforce for 70%, that there needs to be a time period in which to justify or find a basis of evidence that you have been discriminated based on your sex. Part of what we've done here is we've also moved from having it as just a historic sex-based undervaluation to suggesting that in order to bring a claim, you need to have historic sex-based undervaluation and current sex-based undervaluation. That's where this threshold for having 10 years makes sense, because if there is a justification and an evidential basis for sex-based discrimination, that needs to be able to be proved over a period of time, which means there is a time frame. In terms of the 60% moving to 70%, there is always going to be arguments of where that threshold should be met. The National Party's original intention when they introduced the law had a threshold of, I believe, 66%, which was lowered by the Labour government down to 60. But it is also the case that having a 70% threshold is not out of alignment with what we've seen internationally. If you look at Manitoba, Canada, they also have a 70% threshold for sex-based discrimination. So this will make it a more fair, more robust and more workable regime, but more importantly, it will actually become easier to justify, to find evidence and to make a basis for sex-based discrimination.
The Honourable Jan Tinetti.
I'd like to ask a very quick follow-up question.
Well, that's quite interesting, just hearing the bits there trying to mention like one random place in Canada.
Yeah, one state. And the thing is these are their critical areas, really, when you're listening to her when she's speaking about it, and that's nursing, it's teaching, it's everything that we rely on. It's the people that are paid properly in the things like when you're sick, like it's all right for a lot of these people, like they can afford private health insurance and all that sort of stuff.
Yeah.
But this is just a further attack, isn't it? Like, like all the austerity, it's just the next level of grinding these people down, pushing them out of that. And I bet you in the private sector, they'll probably get pay equity. It's just to shrink the public for good systems. Like our public teachers, obviously Seymour needs some more teachers in his charge. All those teachers that were probably going to have a claim in the public system, now they don't. But hey, if they're silly enough, well, I suppose it's not whether you're silly enough, you've got to survive, don't you? So you don't get to make your claim, or you can go and get the same as what a man gets paid at Seymour's charter school. It's just to shake people loose.
Yeah, well, Seymour's charter school, if you can actually find one of them.
Yeah, well,
considering what
sort of lunches do they get there?
Oh, they might have a Michelin star chef.
Yeah.
I think the point though that Jan was making was a really good one, because what she was talking about was when you have industries or sectors that already have high female participation, say over 60%, some cases up to 65 and higher. And they've already started to do the work around because Jan talked about there was a history of sex-based discrimination within specific sectors. So they've already started to do the work around preparing a pay equity claim.
Yeah.
And I think that's where a lot of the concern and the anger and the frustration has come out in the last few days, because we already have sectors at the moment that are preparing or have been preparing pay equity claims and have been doing so for quite a few years. And now we've had, in one day, we've had a minister come out and give a press conference on Tuesday and basically say, that's it, all gone. You can forget about it. Effectively, you can forget about it. I mean, she did introduce this criteria that they're now going to reapply to all claims that haven't been put in. But I mean, I think it's pretty clear that the bar is going to be set so high that it's going to be very difficult. And I think that's what a lot of the anger and the frustration is about for the existing claims that are yet to be put through the process, because the rules have been changed on all existing all existing sectors and parts of society. Whereas there's been no consultation and no discussion and no involvement with wider society about those changes, and I think that goes to explain part of that real immediate response that we saw on Wednesday and Thursday and Friday, and we will see for the next months. So yeah, I think Jan really nailed down that issue pretty well.
And that'd be tough, eh? Like, you've spent all this money potentially paying lawyers. It's not just that; it's the time that you put everything together. It's a hell of a lot of work, And
it's a hell of a lot of work, yeah.
Yeah. So if you had the select committee, at least if you went through the normal process of the law going through the stages, you could at least double down and try and get those claims going through. It should take 3 months, 6 months to pass a law like this, and some of them would be able to get their claims through. But like you say, some of them are probably that close to filing. But filing claims in a court or doing anything in a court, you've got a waiting list, haven't you? So
exactly.
Yeah.
And part of the process that would have occurred during the select committee would have been a discussion about all current claims and ones that are currently being worked on, about how you can get them accepted and put through the process before they changed the rules. That would have been an active discussion during select committee, whereas now there's just no opportunity for that because, Brooke van Veldon came out and she just said, no, nothing happening. She just kind of really slammed the gate closed on everything. And I think if you would have had that select committee process, that's where you would have had the opportunity to really have a good, solid discussion about how we could really have a much more inclusive process around those existing claims before moving into a new, this is how you make the best out of a really bad situation. But no, this is where we are.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram.